Welcome to 59 Minutes. My name is Levi Kones. This morning I want to talk about what you should know about succession. One of the things we don't easily talk about, but yet is part of life, is the fact that one day we will die. And when we die, or people close to us unfortunately die, then it triggers off a series of events with matters, successions, once we have dispensed of the funeral procedures and things like that. And a lot of us do not know where to start, who to go to, what to do, what to expect, how long the procedure is, all those kind of questions. This morning, we want to begin to answer them, and to join me in having that discussion is a lady who's an advocate of the High Court of Kenya. She is FLORA CHEBET. Karibu sana.
Asante.
Glad to have you here.
Thank you, Levi.
Yeah.
I'm glad to be here too, and I hope our viewers will enjoy and learn a lot from this session.
Yes, I hope so too. Tell me, Wakili, I know on average not so many of us know these procedures, but tell me, how bad is it when you see people come to your office? How bad are we? Are we not knowing? Are we clueless?
Okay, it is not as bad as it seems to be. Actually, nowadays people are improving. They are starting to seek out now the services of an advocate, or so that the advocate can come in and help to interpret the laws, guide on the procedures, and tell you what to expect in terms of maybe timelines, the court processes, and the law generally, based on the facts of the situation.
So sio mbaya sana. This
watu
wameanza kuamka, ni shida zimetuchapa.
Yeah, alafu unaona sasa saa zingine you do it on your own, ukifika mahali you find it's becoming difficult. You need services of an advocate, or rather you need legal advice. So based on case-to-case basis, especially in contentious matters, people seek the services of an advocate, even in uncontentious matters, because now when you have the legal know-how, it even, it lessens it makes the process easier. And then it also relieves you of some, stress, because, there are some maybe legal technicalities, especially procedures that people might not know. Though succession has been, some people prefer to do it by themselves, especially if it is non-contentious, it is not as difficult as it seems to be. Yeah.
Non-contentious meaning if it is not being fought about.
Yeah, non-contentious means it is not being fought about. Families are in agreement, and as to, especially now when there are issues like if you have a will and everything is outlined in the will and everyone is agreeable to the terms of the will. And if it is someone has died without a will, then in those instances, people are also agreeable on who is to get what, based on now who the deceased has left and what the deceased has left.
I hear you.
Yes.
Now, tell me, in terms of where to start from, at the point of death of a parent, let me say, or of a spouse, what should you have before even you talk about succession later? What are the documents you need to be getting and having in your possession by the time you come to the issue of chasing after succession? And how long after burial should you show up for such, a procedure to start? Okay.
So in terms of what you should have, first of all, you should have proof that now the deceased, or rather the person, the deceased, that means the person who has died, Okay. So death certificate is what you need to have. And then again, you need to report to the chief. So what we normally advise people to do, you just go to the chief and tell the chief, we want that letter that shows that the deceased came from your location, and these are the people
so
he has left.
There's a letter from a chief?
Yes. So the chief, normally, if it is a man, the chief will say that this man, if he was married, has left a wife and maybe children, if he had children. If he was not married, he will now go to maybe her father, mother, and then the siblings of the deceased. Yeah, so the chief normally knows what to write in that letter.
So you start at the basics of the chief. You get a letter. Where do you go to with your letter?
Yeah, now when you have that letter and the death certificate, then you can be able to now start working on because there are start working on the succession matter. So now it depends. If you have a will, there are some forms that will be filled, and then if the deceased did not have a will, that is, he died intestate, then there are also forms to be filled. Yeah. So then now at that point, it will go to court after filling them for filing. Yes, yes.
How long before? Because usually people wonder about the timeline. And of course, you know, given the fact that someone is mourning, and it's a loved one, sometimes you can find yourself in a mourning limbo for a very long time.
Yes.
How long is soon enough? How long is too long, you think? Or is there such a thing as too long after, you know?
So in terms of timeline, we normally advise whenever the family is ready, because now, you know, grief is personal. You don't know how it has affected the family. So some people can be ready as soon as maybe 1-2 months later, or 3 months, and then some maybe can take a year, which is still okay. Yeah, provided now, you know, it also depends, because some people can take time before they obtain those letters. Not letter, the letter from the chief, and maybe some might take time before they go to obtain the death certificate. So it depends with how ready the family is. Yes.
So the death certificate is not usually granted upon burial?
Yeah, it usually does, but sometimes there were, I think, maybe technical delays or something of the sort, so you might find people have delayed maybe in obtaining that the certificate, or maybe but usually it's supposed to be given before the burial, because now you're given the burial permit and then the death certificate.
Okay. Where there is contention, because that is why some of these topics come to the forefront. That is, you know, why we are even talking today, is because many times, or in some instances, let me not say many, there is contention where, you know, 2 siblings cannot agree, a parent has died. 3 siblings, 4 of them cannot agree on, and then you find issues. Somebody CG has hidden the death certificate, somebody CG has, you know, done this or the other. What are the things people should watch out for before even they make an application for the next step in terms of administration of this person's estate?
Okay. First of all, let me start with an instance whereby now someone has died without a will. Yeah, because in that case, because in the will, you would have appointed maybe the executors of the estate, estate of the deceased. Yeah, or maybe even if you have not appointed, there's a procedure in court which will be done, but now the issue of distribution of property will be well done in the will. So now, in an instance where someone has died without a will, let's say this person was married and had children, so the first person who has the right to apply for, because now you must apply for letters of administration of the estate. So the first person who has that right is the wife. Now that is outlined in section 66 of the Law of Succession Act. So that act is basically what guides us in now dealing with anything to do with succession, be it now when someone has a will, and be it someone does not have a will. So based on that, if someone is married and has children, the first person will be the wife. So if now if one of those children is also an adult, then it can be the wife and one child who can be the administrators who can apply. Then now the rest of the people can give their consent. Let's say the other children are also adults, then there's a consent form that they sign to having their mother and maybe brother being the administrators of the estate of their father. Yes.
So hii application inafanywa wapi?
Now there are forms that are usually filled. There are forms that have also been provided in the Act that are filled. So most of the time, if someone is having a challenge, I would advise you visit the nearest advocate for assistance, so that now they can guide you on what to do and the right forms to be filled. Yes, or maybe if now someone cannot, maybe they're saying they cannot afford an advocate, you can visit the nearest court station, and then you go to the registry. They also advise people on what to do. Yes. Is
it so expensive? Because the moment we talk about an advocate, most people shy away there.
Okay.
They say, hey, you know, lawyers ni watu wa pesa.
Okay.
You know, how expensive or affordable can it get to find a lawyer?
Okay, for us, the advocates, we are guided by, there's a scale. Yeah, it's a scale that gives now, you know, how to deal with now the succession issues. So you see now for succession, we can't say there's a standard figure that we are supposed to charge. We are only guided by the scale. So it depends also on the estate of the deceased. What are you dealing with? What did the deceased leave? Yeah. So in terms, because
so mnaangalia kwanza kama kuna malls maduka nini, mnasema bas scale ndo hii.
But the scale is fair enough. The scale is fair enough. Yeah, because
it's commensurate.
Yes, it's called the advocate's remuneration order. So now that one guides us in what to charge. But it is fair.
Yeah.
It is fair.
So for people who say we don't have much and we can't afford a lawyer, how would you advise such a person? What do you do?
Okay, if you can't afford a lawyer, you can visit the court registry. Yeah, preferably the nearest court, or the nearest court, and then you go to the registry. You talk to the court clerks. They are very friendly. Then they will also guide you on the forms that you need to fill and the procedure. Yes.
So it's possible to have what you call the court-appointed attorney.
Not really
court-appointed, but ile una unajitafutia tu.
Yes. Unaweza jitafutia wakili. You have the freedom, because even the Constitution of Kenya gives everyone like a right to representation. But now you see the ones that are, it's mostly in criminal matters that you can say you can have a court-appointed advocate, but also in specific cases. But now in this one, you can just go for, if you can't afford the services of a lawyer, you can visit the court station. They will advise, because now you see they work with the magistrates and the judges. So they will guide you on what you need to file. Yeah. And then now you can present them in court for filing.
So in a nutshell,
yes.
In terms of filing, we want to apply for letters of administration.
Yes.
Generally, what do they ask for as you're applying?
Okay, well, they will ask for the details of the deceased, where he died, the date of death, and then whether there was a will or not. Now, based on that, you will fill the right form. So if he died without a will, then you will be applying for, it will be a petition for grant of letters of administration. So first, that will be the first stage. So you're given that form, so that now the other people who also have a right to apply for those letters can give their consent and say, now I give consent maybe to Levi to be the administrator in the estate of the deceased. Yeah, and then now after that you're given a grant. Yeah, just a temporary one before it is confirmed. So the second stage now is confirmation, and that's where now distribution of property.
How long does it take from the grant to confirmation?
So first stage, first of all, there's filing and then gazettement. So gazettement, you're given 30 days period. Gazettement now, those documents are sent to government printers, whereby now they are advertised in the Kenya Gazette. So if anyone has an issue in terms of now being those letters of administration, they are presented with an opportunity to object. If you have an issue like in terms of appointment of those administrators, you can object within that period, which is 30 days. And then after that, if there is no objection, then you go to the second stage, which is to apply for confirmation of that grant. So then you wait for 6 months before it is confirmed. So basically, if you do the math, maybe around 7-8 months thereabout. But now it depends. If there are objections in between, then it will take time, because now the court has to make a ruling. Yeah.
Now, in the event, for example, let's hypothetically speaking, let's assume me and you are brother and sister.
Yes.
And it's our parents who have gone. And you, have already moved for an application for the same. How will I be aware that that has happened, even when the Gazette? Because sometimes you have one sibling already looking for letters of administration. Other siblings are still in mourning. They don't know what's going on. They are not, pengine hawajasoma sana. They are clueless. How do I, is there any way of other people being aware? Or is it upon them to just keep checking these Kenya dates?
Okay, yeah.
You know.
Yes, the best way actually is to keep checking now whether there is that, whether it has been gazetted. Because, and then first of all...
So the loophole is there. If you don't check, inaweza kupita.
Yeah, yes, somehow. But, well, unless if you are not, but somehow people know, because there was even another one that was contentious, and the whole family, the brother was disputing the appointment of an administrator. And he was aware. Though in between there were some documents that were obtained without following the due procedure. Yeah. Yes. So you have to keep, that is the most, the surest way. So is to keep checking. Yes.
I think this is why they have those meetings immediately after burial.
Yes.
Ideally, they are supposed to discuss such things.
Yes, because now
and their framework. Yeah.
Yes, if someone has died and then he's left a family, then the best person to take out those letters of administration is his wife, and maybe children, yeah, or maybe his parents, because there's a hierarchy. So if he didn't have a spouse and he's not even married, he doesn't have children, then the next person would be his father. If his father is dead, his mother would do it. If his mother is also passed on, then the next person would be his siblings, either brothers or sisters, and they rank equally. There is no discrimination as to who has a higher right between the siblings. Yeah, and then if the brothers and the sisters are also passed on, then you go to check grandparents, step brothers, they all rank the same. Yes.
So it always goes until it finds a way and finds somebody who can execute.
Yes, because in some instances, maybe someone was an orphan and he has died, he has left some property. So you look at the hierarchy of now relations, who is the closest person, according to Section 66 of the Law of Succession Act, who can take out the letters of administration.
Yeah.
Yes.
So there's currently no database to check and see whether something is already ongoing.
Well, there's Kenya Law reports. They have they normally report the gazette notices that have already been printed by the government printers. Yeah, so you can always check from Kenya Law reports. Yeah, there's a place for gazette notices.
Okay.
Yes,
okay.
Yes, or you can visit the government printers physically if you can. Yes.
Yeah, I know where they are.
Yes.
They've been at the same place, by the way, since independence.
Yes.
It's a very interesting thing right there.
Yes.
So it's very, unraveling the issues of succession are quite, a big conundrum. One of the things you have constantly mentioned out is the issue of the will.
Yes.
And for most Africans, I don't know, in your experience as a lawyer, maybe you can tell us how many of us are writing wills on average?
Very few people.
Out of 10, how many people do you think are writing wills?
Maybe I can say 1 or 2.
1 or 2.
Yeah, out of 10. But I think we are a conservative society, but people are starting to embrace it. Yeah, so people maybe feel like if I write a will, am I calling death? Am I having a premonition that I'm going to die soon? But that is not the case. It's just that a will has many advantages.
Yeah.
You know, it gives you the liberty to decide, like apart from my nuclear family or my close members of the family, I can also gift a friend, or I have liberty to dispose of the property the way I want. Yeah, and then you can also, decide what share is given to who. Yeah, so liberty, the will give you like so many options compared to when you don't have a will.
Yeah, I hear you.
Yes.
A will is definitely a good thing in that regard. Yet, we are in many families where we don't have wills.
Yes.
So, what to do? How do we know mzee alisema nini?
Okay.
Of course, now, let's say he has gone, and now your brother is saying, oh, before he went, he was just saying, levy. If I go and claim, how do we know that's true? How do we know? Especially when it comes to matters oral. Tell how do you guys deal with it?
Okay.
Yeah.
So you see now for wills, the wills take like 2 forms. There can be a written will and there can be an oral will. So for the written will, there are different set of rules as to how to make it. And then now for the oral will, before you make it, there has to be 2 competent witnesses who can now tell that before Levi passed on, this is what he said. And their statements should be similar. There shouldn't be contradictions in what they are saying. So then there is another thing, an oral will should be like now made within 3 months before death. Like it should not exceed 3 months before the maker dies. So it should be done within 90 days period, after death. So not after death, but before death. That is the limit. It has a time limit. So
anything within that period after 90 days is hakuna last testament,
Now, you see, for oral wills, people are busy sometimes. You can forget. So if we extend the time limit to 1 year or 6 months, people tend to forget, because now you will start saying, this is what he said. The other person will say something that is different.
Okay.
Yes.
So it has been within the last 90 days
Yes.
of their life?
Yes.
Okay.
Yes.
So even up to even yesterday, when somebody went today, that counts?
Yes. And then now there's an exception, like we are in active service in the military. And you die, and then that 90-day period has lapsed. It can still be construed as a valid will, because now you are in active service. Umeenda pale Afghanistan, you die in line of duty, so, and you had made an oral will during that time, then it will still be valid.
Okay.
Yeah.
So in the absence of that, let's say we didn't prepare, a road accident has taken someone away. And they've never told anyone anything. They have never spoken about it. They were not expecting they were going to die, but unfortunately it has happened.
Okay.
What to do?
So now, if you don't have any will whatsoever, whether oral or written, the rules of intestacy apply. So the rule of intestacy, now we revert back to the Law of Succession Act. Now that will guide us on how to divide the property, now depending on your circumstances. Like if you are polygamous, you have 3 wives, how do you divide that property? So the Law of Succession Act is what guides us when someone has not left any valid will or any will whatsoever. Yes, but it has to be valid.
It has to be valid.
Yes,
That's
it has
true.
to be valid. But the best form of will is a written one, and then it's also best to engage an advocate so that you comply with the rules that have been given. Like now in terms of preparation of the will, it has to be also attested to by witnesses, 2 competent witnesses. So people of 18 years and above who have the right mental capacity. And then it also has to be in writing, and then it has to be signed by the maker. So signature can be, if it's someone who cannot write, he has to give directions as to the contents, and then now maybe affix his thumbprint. Yes.
It's still something that needs to be talked about a little bit more, especially in our setting.
Yes.
And in as far as issues of succession that have to do with how do I put it, with legal frameworks that still need to be worked on. For example, you've lived with someone but you don't have a marriage certificate, or you are in a polygamous relationship and you are wife number 3 or 2, or you are a son, but a son from outside wedlock, or a daughter from the same, and here's a situation where you want recognition. What's the best way to go about it? Okay,
so one thing about the Law of Succession Act is that it has covered the children. Children, like, as long as you can prove that so-and-so is your father or your mother, okay, let's say father mostly, because that's where maybe most most problems arise from. So as long as you can prove, like by having a birth certificate, or if it is contested, you can do a DNA. So as long as you can prove that the so-and-so, the deceased is your father, then you are good to go. You are adequately provided for in the Act. because now you see the Act covers the children under Section 29 of the Law of Succession Act. It has defined who a dependent is, and for children they are covered there, and it doesn't matter whether you have to prove that you are depending on him before he passed on. Like, it is just absolute. Yeah, so whether you are born out of wedlock, or whether you are born in a polygamous family or monogamous family, as a child, you have a right to inherit. And then now the Children Act of 2022, it's number 29 of 2022. It was passed last year. Yeah, so it has also covered that. Under Section 17, it has exclusively stated that children have a right to inherit. Yeah, to inheritance. And then there's also a punishment or penalty for if you try to disinherit or maybe to deny the child that right. Yeah, so it is well protected. Children are well protected under the law of succession.
Okay. I'm going to take a quick break on that note. But when we come back, we are still talking about succession. Don't go away. We'll be right back after these messages.